Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this Honorable Court. Be seated, please. Case number 23-1160. Thomas Shands, appellant versus Commissioner of Internal Revenue. Ms. Blank for the appellant, Ms. Abeka for the appellant.
Good morning. Before we get started, I just wanted to confirm, so we're having open proceedings in court today, and do parties agree that also the briefs that you filed in the court are open, and if not, clarify and maybe submit something right? Terrific. All right, so we have that on record, and then we're ready to proceed. Ms. Blank, when you are ready. Good morning. If you want the podium down, you can adjust it, but it's fine.
Good morning. May it please the court. My name is Stacey Blank. I'm here today on behalf of the appellant Thomas Shands, and I've reserved 2 minutes of my time for rebuttal. Mr. Shands seeks a whistleblower award in connection with OVDI proceedings involving the U.S. clients of the Swiss bankers and banks he identified in his whistleblower information. The IRS denied Mr. Shands' claim for the purported reason that it did not take any action with respect to any taxpayer who participated in the 2011 OVDI program. Mr. Shands sought review of that denial in the tax court, and the tax court dismissed his petition for lack of subject matter jurisdiction for the same reason, that is, that the IRS took no action with respect to any taxpayer.
Can you clarify what your client was requesting? Because it seemed like you might have been requesting 30% of the $2.1 billion that the entire program brought in. But then on appeal, you seem to be trying to narrow that to certain particular taxpayers, but that's not really the record who that would be. And it's not clear that that was requested in the court below.
So, from the very beginning, from Form 211, Mr. Shands indicated that his claim would encompass the proceeds that the IRS collected from others, including the clients of the bankers and the banks.
So all of them, including the specific ones?
Correct. And so the ones who were particularly the customers of the bankers and the banks were a subset of the broader. But again, keep in mind that this has always been limited by the fact that in a related action, you cannot be more than one step removed from the original actors. And so,
an alternative theory, though? Related action, is this all one theory, or is the related action an alternative theory to this proceeding?
Well, I would not say that it's an alternative theory. I think that the related action addresses the concern that the government raised that the participants in the OVDI proceeding were not specifically identified. And so in related action, of course, you don't have to specifically identify. And so that's why the related action is important to address the issue with respect to the specific U.S. clients, that there was no requirement for Mr. Shands to identify them so long as they met the remaining tests for being related action.
If we were to agree with you that the tax court did have jurisdiction over the petition, what would you have us do? Should we reach the merits and decide? You say in some places the court should decline to reach the merits. Then you say to the extent the court is inclined to consider the merits.
I think it depends on how strongly you agree with me and on what points. Mr. Shands contends that all of the OVDI proceedings are administrative action. And if in fact that's the conclusion that the court reaches, then I think the appropriate remedy would be to remand to the tax court with instructions that the tax court then further remand to the IRS for calculation of the award.
Administrative action is only a threshold question, and it's unclear to me whether we would need to reach that. I know that's the ground on which the tax court relied, but I take your position in part to be that the Form 211 here is the in fact, not in part, but wholly, that the Form 211 that was filed is the basis of this action. And therefore, that to the extent the IRS is treating the OVDI taxpayers' claims as a separate action, you would be arguing, no, they are a related action, or because of, they were based on the 211. So whether it's based on or related, your argument is, in a sense, is beside the point whether there was any administrative proceeding separate and distinct from the undisputed administrative proceeding that already supports the whistleblower award that Mr. Shands has received.
I think that's right. It's been the government's position that every slice of this has to satisfy the requirements of being a separate administrative action. And of course, Mr. Shands has disputed that. But I think even if you were to accept the government's position on this, each individual OVDI proceeding with respect to a client would be an administrative action under the definitions in the regulations. And so therefore, even if you accept the government's position with respect to it wasn't the 211 that gave rise to a single action and then everything flowed through that. I think that Mr. Shands has demonstrated that even if you reject that position and you look and see whether every separate claim number that was assigned by the service to Mr. Shands' claim satisfies the requirement of an administrative action, it does.
And I think the service responds every tax filing, every taxpayer who files a correction or a missing return or correction, does that automatically in your view become an administrative proceeding?
No, not at all, but this is very different than that.
Do we know enough to conclude that this is very different from that?
I think we do. I mean, we understand what happens in an OVDI proceeding, even though we don't know exactly what happened in each of these. We know what's required in the initial application. We know that the taxpayer has to provide not only the original returns and corrected amended returns, but any informational filings that relate to the offshore assets. Taxpayers have to file statements identifying all of their offshore assets, all of their bank accounts. They have to identify the banks in which those accounts are held, and they have to identify all the people, the facilitators is the word that's used, or people who help them manage those assets.
But in most cases, they submit that information, and then they just pay what they calculate to be the penalty or the back taxes, and there's no action by the IRS.
I don't know that to be true, because what happens next is that, well, it's assigned to then a revenue agent or an examiner who then conducts a fairly comprehensive review. Now, I think the government would say not a full examination, but as in my reading, the only thing that's different between what happens then and a full examination is the scope. Then the revenue agent...
So the examination is an audit, right?
That's exactly right.
It sounds to me like what they're doing in this OVDI program is not so different from when we file our taxes.
No,
we have self-assess, and then we say this is what we owe.
Well, that's the first step, but that's not the only step. Then the revenue agent looks at it and says, okay, do I want to ask more questions? Do I want to send document requests? And they do often. Do I want to conduct third-party witness interviews? Which they do. And so
I guess the bottom line is sometimes it's an action, sometimes it's not. Because if all they do is review the information and accept what you say you're going to pay, it's not an action against the taxpayer.
Well, I mean, there are a lot of characteristics of it that are much beyond what you do if you just file a corrected tax return. You have to sign an agreement, for example, to extend the statute of limitation on any taxes or
action against the taxpayer. Do you agree that to be an action has to be an action against the taxpayer? That's in the statute.
Well, I mean, yes, but in the same way that an audit is an action against the taxpayer.
It's very different, though. That's the agency taking steps to examine the taxpayer.
Well, I would say it's not really different if the revenue agent to whom the OVDI file is assigned says, okay, I want to bring you in and ask you a lot of questions.
Well, I want to do that. They got to say in some cases it's not, and if in some cases it's not, it seems like it's incumbent on your client to do more, than in this case it was.
Well, that's an interesting issue because, of course, the IRS would not give us any of the information in the tax court that we asked for because